Good evening, everybody. Welcome to the live stream. This is Jonathan Ginsberg, and today I'm joined once again by Adriana de la Torre. Is that how, am I pronouncing it correctly? De la Torre?
Yeah, de la Torre.
Okay,
Yeah.
okay. Well, welcome back. Adriana is a well-known in the Social Security world for doing federal appellate work, and she also posts frequently on LinkedIn about interesting cases and so forth. And I think the appellate area is really worthwhile to know about, because I'm doing the hearings. I'm kind of in the trenches, and many times things that are happening at the circuit court level, district court level, I don't really see them, and we find out about them through some of these cases, and sometimes they can be very useful things to do at hearings. One thing I mentioned, I put this in the comments. If you're hearing an echo, let me know, and I can put the headset on. I think I've got it set up where we shouldn't have it, but if there is an echo, please let me know, and then I will make sure to put the headset on so you won't have the echo. But anyway, Adriana, nice to see you again. Hope you're doing
Great
well.
to see you. Yeah, I'm really excited to be back. I had such a great time last time, so
Very good. Yeah,
I'm really
it's kind of
excited.
fun to do this. I really I've done it now for about a year, and it's actually kind of fun to answer questions on the fly and just sort of think of things that I really otherwise would not have thought of. So before we start going to the questions, let's talk a little bit about. There was a recent Nascar conference, Nascar being the National Organization of Social Security Claimants Representatives. And obviously this is a really interesting time, let's call it, in the Social Security world. We have a new commissioner. There's a lot of changes. There's been a lot of buyouts. So let's start with that. Anything of interest at Nascar that you thought was particularly something that people need to know about?
Well, I thought this NASCAR was particularly great because it was in DC.
Mm-hmm.
And because it was in DC, there's an advocacy day. And so it's called Hill Day, where we get to go as claimants representatives and go talk to the congressmen and congresswomen and talk to them about the struggles that we see, Social Security in particular, and what it's like with, boots on the ground, which is what we have representing the claimants. And it was really interesting. I got to meet with the two Florida senators. Well, their representatives. I didn't meet with the actual senators, but I met with their representatives. And we also met with several of the Florida House representatives as well. And, everybody was very interested in what's going on. Everybody was interested in how it's affecting the claimants, which are their constituents. And a lot of people don't know that they can reach out to their congressman
Oh, yeah.
if they're having any trouble within the agency, right?
Yep.
Slow application, releasing of funds is getting difficult. You have a long wait time for a hearing. I mean, the only people that can really enact change is Congress, right? For Social
Yeah.
Security.
Yep.
They can rewrite how things are regulated. And so that's always important. So it was really good to go and advocate. And I really had a great time. I also loved the West Wing when I was younger. So this was like an absolute dream for me to go there and, see the subway underneath, right?
Yeah,
And
yeah. No, I've never done that. I've never done that. Yeah, I wish I could have gone this year. As I've mentioned before to those watching, we had some issues. My father-in-law fell, and we had some medical things we had to deal with. Everybody's okay now, but I just couldn't go. Any sense of, because I know one of the things that there's always seemed to me to be a bit of a disconnect between what the representatives, our elected representatives, kind of know and what we see on the ground on a day-to-day basis, the long delays, the lost files, all that kind of nonsense. Do they know what's going on? I mean, or are they sort of not really aware what's happening?
I don't think they're really aware of what's happening because if you're not really in it, if you're not living it, I don't think you understand, right? So every year, Social Security comes out with their statistics, and this is how many cases were filed, this is how many appeals were done, this is what the agency level, award rate was, like how many ALJs paid, and all that stuff. One of the most important statistics, which we brought to their attention, was that after you go through the administrative process, right, you get denied 4 times, you have to go to federal court. When you go to federal court, you can get either what's known as a remand, which is your case goes back to Social Security, or you get an affirmance, right? Your case is fine, they don't see anything wrong with it. The federal court for 2024 had a 63% remand rate,
Hmm.
which means something is wrong within Social Security. There is a disconnect between what's happening at the agency level and what should be happening. So, that was a statistic that we wanted to really advocate for and say, hey, you really need to start looking at this, because this is showing that the numbers are not correct, that they're not adjudicating these cases correctly at the agency level. They shouldn't be getting here to get that remand, right?
Although to be fair, I mean, I assume, and I know for a fact, you don't take every case that comes across your desk. I mean, you can't. So these are the ones that and people who do what you do, look at it and say, there's clearly something to be appealed here. But nevertheless, the point is that there's enough of those to keep you busy and to keep other people busy. So I'm guessing that there is a problem there.
Yeah,
Right.
it's a 63% remand rate. I
Mhm.
mean, more than half these cases are being sent back because something was wrong.
Yeah.
So it shows that there is some sort of disconnect. And the only thing that I think becomes the sticking point really is this a policy question that we need to kind of rework, or is this an administration issue that we need to get involved with? And I think that's where we need to advocate for. I think it's both,
Yeah.
right?
Yeah.
Like, I think it's both, reforming some of the policy that is done within the agency, along with changing some of the provisions, right? I mean, I know I have loads of ideas, but
Yeah. Nobody asked you, right? They don't ask us. Right.
nobody at the Senate have
Yeah.
asked me anything.
Yeah. And I notice a lot of in your LinkedIn posts, you'll kind of throw out some ideas and, like you sort of ask rhetorical questions, but obviously these are questions that really policymakers need to really consider. And actually, while we're on the topic of remands, just for our audience, give me a sense of what the most common reasons that a district court would basically say to both the appeals council and to the ALJ, you screwed up. What are the common things that you see, if there's
So
any common things?
it's interesting because the appeals council will remand a small percentage of cases on their own. They're not looking at the federal court cases on why we should remand. The
Mhm.
appeals council is looking at strictly just what do our own rules say? And did it kind of fit within our own rules? There is a very large disconnect there because different regions apply things differently, right?
Right.
And so that's an interesting one. I would say that what they're looking at there is making sure that VE testimony is supported, right? That there were jobs that were cited, that there were DOT codes that were cited. They really look at that step 5 at the appeals council level. They leave a lot more discretion to the ALJs, but they're just looking to make sure that everything seems supported at that stage. I'd say at district court, the bigger issue is more an ALJ kind of reading evidence and analyzing evidence that really takes a doctor to look at and not a layperson, right? So it's
Mhm.
not the judge, it's not myself, right? We can't be looking at an MRI and say, well, you have stenosis and these couple things, so you can do light work, right?
Mhm.
But that's what a lot of the judges do. And so the issue is, well, why does that say light and not sedentary? If sedentary, which would require you to sit more, would mean that you're disabled. So I think district court looks for more of, you didn't really connect the dots. You didn't really support your assessment of what you think this person can do. And you have no medical opinion to kind of back you up on this. And so that's where I think the district court tends to remand a little
Did,
bit
did
more.
did the district? I know that one of the things that I've noticed the last couple of years, and we're going to get to questions in a second, everybody. But I know that one of the things that's been going on is the DOT, which you mentioned, or this stands for Dictionary of Occupational Titles, which is a department. I think it's a Department of Labor publication. It was last updated 1990 something. You were probably in
Yeah.
diapers at that point, right? But it was a long, long time ago. And the point is that there are jobs in there that don't exist the way they did in 1990. I mean, we're now 30 years after. So I mean, it just doesn't make any sense. And I know there was some moves by Social Security recently just to specifically identify these jobs are no longer to be considered, or the DOT is no longer. There's this whole now, I guess, a protocol that judges go through to question the VEs, the vocational experts, about where their numbers came from. Is that all from district court or circuit court, actions? I'm assuming that's where that came from.
Well, yes and no. I
Yeah.
think the agency for a long time has always known that they can't be relying on the DOT forever. They just can't. And so there had been a lot of internal movement on, we need to figure this out, we need to update this. And it was at the same time that those cases are coming back saying, how are you finding this job? It doesn't exist. Microfilm doesn't
Right.
exist the way it
Right.
did in the 70s. I think the end result was that they came out with an emergency
Right.
message to eliminate several jobs, but they also issued a new ruling, which is SSR 243P, and that talks about what a VE testimony is going to be like, what the ALJ is supposed to ask, and how the ALJ is supposed to consider that evidence. I think the problem is that we haven't really seen it in practice enough to know what's going to happen with that. I think that it's going to cause a lot of differences between judges because I think there's a little bit more leeway on what is a significant number and how can you find it and what are you going to rely on to get those job numbers. So it'll be interesting to see how it works in practice, but that'll still be a couple, maybe a year or two before we
Right.
really start seeing
I
those
mean,
cases.
my personal sense is that we don't know how many jobs that exist in any particular job I
Of
mean,
course not.
how are you possibly going to know? I mean, and again, without going into the weeds, but now there's all these different statistical things you can look at that, within, let's say, one DOT code, there may be, 15 other codes that are now, so it makes no sense that there's no way to really know. And again, I think that Social Security has decided, well, this is the best we can do. But the reality is, I mean, I've had hearings where, the vocational witness will talk about, there are 89 jobs. Well, that's not a significant number. You can't deny somebody because of 89 jobs that exist nationally. But, judges will
Exactly.
sometimes do that.
And the other problem is that there is no standard for how many jobs is a significant number,
Right, right.
right? It's all up to the ALJ. So you have one ALJ that says 10,000 is, and another one that says clearly 10,000 is not a significant number. It's a nationwide program.
Yeah.
There should be uniformity
There should be
in
uniformity. Yeah.
what is a significant number.
I mean, the thing drives me crazy is you have with VEs, some will say 10% off task is the maximum.
Yes.
Others will say 15%. Well, yeah, that's a pretty significant difference. Some will say
Yeah.
1 day of work a month is too much. Some will say in unskilled 1 day of work is too much, but for semi-skilled or skilled, you can have 2 days. Again, no national standard, so it just depends on the particular VE.
Right.
I mean, it can be very, very frustrating. And now this will be my final question before we go to questions. One of the things that drives me nuts about this area is the wide variation in approval rates by judges. You may have in one hearing office. I'm in Atlanta, and of course, I'm doing cases all over the country now, like most of us that do this. But in Atlanta, the downtown office, there was one judge who's thankfully since retired. 17%, 15%, year over year. Judge next door was 65 or 70%. How can that not be something that Social Security or the courts would not look at? I mean, I just appealed a case for somebody. There's a judge in Charleston, 13% approval rate. I mean, how can that not be something that they would consider? In fact, I was almost going to put in there, reference to some statistical, analysis that a judge is approving 13% is so far, given that the mean or whatever is 49%, I think was the last statistic I saw. But,
Yeah.
If you're at 13%, then you're so far below the standard deviation that almost inherently that's not fair. But I mean,
Right.
would they even consider that? I don't know.
I doubt that they
Yeah.
would. And, that's something that shows that there's a disconnect. Those cases come back. That particular judge may need retraining on policy, on
Yeah.
how
Yeah.
you're supposed to implement the treating physician, how you're supposed to implement opinions, because that's showing that something's not right.
Something's
If the
not right. Yeah.
average
Yeah.
is
No, I remember I put
51%.
on the Nascar listserv, I said, I've got this judge. And so somebody piped up, well, I'm in Charleston, South Carolina, and I've been doing this for 20 years and I've never won a case with this judge. Well, I mean, what does that tell you? I mean, that's just insane, but
Yeah.
it is what it is. Okay, let's jump into some of the questions here. All right, so this person has a multi-part question. Lawyer backed out of me because I needed an in-person hearing because of the tinnitus and hearing loss. Firm was out of state, failed back, misplaced hardware, suffer from Lyme disease, body-wide, and then there's a number of different things going on, depression. So, well, let's kind of make this more general. In-person versus virtual, which virtual being telephone or video. Any sense from your end that is there any difference in terms of the approval rates? Is there any sense that the courts look at those cases differently depending on live versus virtual?
They don't really. I mean, the
Mhm.
district courts are only looking at the hearing transcript, what
Okay.
was typed up. That's it. Nobody looks at the video feed. Nobody is getting the hearing recording that you can hear how the person's testifying, what they're talking about, if they're crying. Unless it's talked about, it's not in the transcript, and that's what they look at. I don't
Okay.
think that there's much of a difference between in-person hearings versus video hearings. It
Right.
really just kind of depends on who's looking at your case. That's why Social Security is so hard. It's a
Yep.
subjective process.
Yep.
So I think the bigger issue is whether you're in person or by video, you need to make sure that you address everything. If you came in with a cane, kind of pick it up and wave it
Right.
around on the video and say, this is what I have
Or if
to
it's a
make sure.
telephone hearing, say I'm using a cane. Right. It's got to be
Exactly.
in the transcript. Now, the interesting thing that this person talks about is all these medical issues, taking prednisone, oxycodone, had my thyroid removed. And then he or she says, how much more do I need before I'm deemed disabled? And I think that, the big picture here is, and I'll answer this one, you don't win on a diagnosis. You win because of the
Yeah.
functional issues that arise from your problems. So if you have a thyroid issue, what does that mean in terms of your functioning? Are you fatigued all the time? Are you not able to get sleep? If you're depressed, and you're treatment resistant, and you've done ketamine, which is a kind of a last resort, body-wide inflammation. What does that mean in terms of your functioning? So the way you have to look at this, tell it all now is the person asking this question, is not about the diagnoses. I mean, the diagnosis will get you past, okay, this is a severe condition. It's been diagnosed, but you don't win because you've got, hypothyroidism or Hashimoto's or whatever. You win because of the effect it has. And that's really what Social Security is really going to be focused on, right? I mean, that's what I've always looked at.
Yeah, and I think it's important to know that when you do get a denial, most times it's not the agency or the judge saying, "You're fine. You're absolutely normal. There's nothing wrong with you. You have no conditions." What they're saying is, "Yeah, you have some things wrong with you. You have some conditions, and they limit you in some way,
Right.
but they don't limit you enough to eliminate all work." And I think that's where most people get stopped. It's not that they didn't have evidence, it's not that they didn't have the diagnosis. It's that, as you said, they're not connecting this is how it impacts me, right? And this is why I couldn't do A, B, C, and D at a job. And therefore, I can't work anywhere.
Yeah. And I think that anytime you are preparing for a hearing, you really want to just, even if you're making a list of the things that, and specifics. I mean, if you have trouble sitting, you don't want to say, I can't sit for too long, or I can't sit too very long. I can sit for 5 to 7 minutes. I'm not going to stand up and walk around because of the pain in my lower back. I have to walk around. I can't stand at my work site. I would have to walk around for 5 to 7 minutes. I can do this cycle 3 or 4 times before I have to lie down for 30 to 40 minutes. And this repeats throughout the day. That's how specific you've got to be. And I think if you think of it that way, because the judge is looking at it saying, I'm going to pose a question to the vocational witness, I want to give the vocational witness very specific limitations. And if the judge believes you, with that level of impairment, the vocational witness is going to say, well, you would be too, again, off task if you're taking 30-minute breaks 3 times a day, unscheduled. That's excessive. But again, it's not because you've got a herniated disc or because you've got whatever the condition may be, bad knee, it's the effect, and do you have medical support for that effect? And I would even go a step further in that your medical diagnosis and the symptoms you're claiming need to be consistent. And I suspect that's something that comes up in appeal as well. You can't say I've got a mildly bulging disc, yet both my feet are totally numb without something else. That doesn't make any sense, right? So, I mean, you've got, it really has got to be, you've got to, I think the way you put it, connect the dots. You really got to connect the dots. Tell it all now basically says, I need to get a lawyer. So again, you don't say where you're from, but I think that if you need somebody, if you want to do a live hearing, then you've got to find somebody in your area that, that does hearings. I would also tell you, look up the judge, and get a sense, because that's one of the things that any attorney who's going to look at your case is going to want to know who the judge is. And quite frankly, unfortunately, if you draw a judge with a 15% approval rate, you're going to have a hard time finding a lawyer, because, lawyers get paid on a contingency, and, no one's going to want to take a case if the odds of winning are just really, really low. And I see you're 53 and you've got a lot of stuff going on, and it looks like there's a lot of things going on here, but, what we don't know is obviously A, where you're from, B, who the judge is, and C, the functional issues that are arising there. Leads me to another question. Let me ask you this, and this is something that I've talked about in a couple recent live streams. Somebody files disability and they've got 10, 15 things wrong with them. Do you find it's more effective to put 15 things down or limit it to 3 or 4 of the most serious strategically?
I think it depends on what those kind of littler ones are. I think it makes it best and strongest of an application to highlight what really is your conditions, right? There's a lot of individuals who say they have GERD and that isn't a diagnosis. I agree, you've been diagnosed with that. I'm not sure that that's going to be what's going to kick you over to disability. So why are we going to add that to the list, right? Why are we going to kind of overcomplicate how we're doing this? That's why I think most times with disability cases that are so complicated, it's boil it down to, what is your theory? Is it that you can't attend, right? You couldn't be at the job because of these reasons, or you couldn't sit because of these reasons, you couldn't stand, and make sure that those are the diagnoses that you do claim, right? Because if you don't say that initially on the application, the ALJ is going to come back and say, well, why didn't you say that you were disabled because of your depression back then? So you want to make sure that you add the most important ones. That's critical. A lot of the other ones that may not, like right now, I have allergies. I have seasonal allergies.
Right.
Unless I have some sort of like migraine component to it or an inflammation component to it that makes it a yearly process, a year-long issue, then that would be different. But I don't think just adding in every single diagnosis works. I think it just makes it a little bit
I would agree. I mean, you might, one thing you could do, you could list it in the application. These are additional things, but and that's, I think, where a lawyer comes into play too, because when you're preparing for a case, you do a pre-hearing brief, and you can diplomatically say, these are the conditions that we want to focus on. These other things do exist. And I always use it, kind of reframe it. Well, this person has fought through, they've got this GERD that causes them, to have an upset, or their esophagus gets sore, or they feel, nauseous at times, but they fought through it and they work. The person's got sleep apnea and they don't get restorative sleep on a fairly regular basis. But they fought through it. So you want to position your client as a fighter. But I think my experience is, if you throw in, 30 different diagnoses, you risk the judge seeing you as a hypochondriac, number one. And number two is that it's going to get diluted. You're going to spend so much time worrying about like I said, the seasonal allergies, the things that are really probably not disabling, and not focus on the ones that are. And look, there, like I mentioned, sleep apnea, and every once in a while it can lead to non-restorative sleep, which might eliminate certain, skilled occupations or even semi-skilled occupations. But you're most likely not going to win disability based on sleep apnea. So you got to figure out where that it may play a small part, but it's not something that I would really bet the farm on, is probably what I would say. on that. All right, so Wayne says, I'm 6 months into my initial application, 53, and diagnosed with cervical stenosis, degenerative disc disease, collapsed disc, and upcoming fusion surgery. Do I tell the examiner about the surgery? I would say absolutely. I mean, you definitely want to tell the examiner. I mean, why would you hide? You wouldn't want to hide it. I mean, I think this, this basically shows you're a surgical candidate right there. That is a commentary about how severe this is. Now, obviously, the question is going to arise, which it would anyway, if the surgery is successful, is there going to be now a closed period you're looking for? But you definitely want to make sure the adjudicators know about all that. And at times they will keep the case open long enough to find out what actually happened. But, this might be a case where if the surgery is successful, and quite frankly, you hope it is. I mean, I'd much rather see anybody, feeling better and able to work than on disability. Maybe you go for a closed period as long as you can show there was a year that you were not able to function. But yeah, I think absolutely you want to tell the examiner. I don't see why you wouldn't.
I don't think there's ever a case for holding something in your back pocket, right? And waiting to see what happens. Let them know. If you get a new medication, tell them. If the surgery gets postponed, let them know, right?
Yeah.
It is making sure that you give them all the information that they could possibly need to make the decision.
Yeah. Yeah. And I think, look, and let them do the work. I mean, let them gather that information. If you tell if you have a surgery coming up, make sure they know who the surgeon is, the hospital, and let them know when you had the surgery so that they can request those records. That can become part of it, because what's happening behind the scenes is the adjudicator, the claims specialist, is gathering that information. Then they're going to send it to a medical specialist, subject to there was an emergency message, but let's set that aside for a second about certain unique cases. But for the most part, they're going to send it to a medical specialist who's going to review it. And the medical specialist is going to see there was surgery right there. Ding, ding, ding. This is serious. And then the question is going to be, how long were you a surgical candidate? Is it, has it been a year? And, how long after the surgery did it take for you to recover, if you recovered to the point where you'd be able to function again? So yeah, there's no reason to hide anything, hold anything back. All right, here's a question. If you go back to work, will your date less insured change? It could, right? I mean, it depends on how many credits you get.
Yeah, it's that 20/40 rule. So, the funny thing about, date last insured is that you're earning credits if you're working, but they drop off, the old ones drop off. So you're not going to keep old ones forever. So it is a moving target. But it depends on how long you can last at that work, how much you made, how much was. So there's a lot of factors that go into it. So it's not just work. It may change based on all those things.
Yeah, and I think the other thing is, there are different sets of numbers. The amount of earnings you have to get a quarter of coverage. And realize the way Social Security does this is you're eligible to generate 4 quarters, 4 credits is maybe a better way to put it, in any one calendar year. And to get a credit, you've got to earn, I don't remember what the exact number is, but it's, I don't know, let's say $1,800, something like that, rough numbers. So I think if you let's say you're earning, $8,000 or $9,000 in a year, you get all 4 credits. And it used to be, I think years ago, you had to get them in a particular quarter. Now you could get all 4 credits in the first week in January, and then not work at all after that, and still have all 4 credits for the year. So it's going to depend on how much you earn. And if you ever get your My Social Security statement, you'll see what the earnings are. And if you look at the credits, and I've got it on my website, let me actually pull that up. I can put that link in here. Give me 1 second. Because I always thought that was just kind of crazy. You've got all these different, tables. You've got one table for earnings credits in 2025. Let's see. Did I update this or not? 2025 is $1,810 of earnings. Yet SGA is $1,620, and trial work period is $1,160. I mean, so you got to be aware of all these different tables. This is, and I realize why they do it this way, but this is kind of why this can be so confusing, because you think, well, it kind of makes sense. If I earn $1,800, well, that's an earnings credit. Shouldn't that be the same as SGA? Well, it's not. and you got to know which table you're worrying about. And there's that
Yeah.
rolling time period, that sort of that 10-year time look back. So it can get very, very confusing. But yeah, I think big picture, assuming you're earning more than $1,810 in a particular year, you may generate more credits, so that might make your date last insured change. And by the way, let me just say this: knowing your date last insured is actually important, because when you apply, you want to make sure that your onset date is before your date last insured, because if you don't do that, you may be found disabled after your date last insured. No SSDI, you'd only be SSI, which may not be viable given household income and all that other kind of stuff. So just knowing all that kind of stuff. And it's really not, there's no place to really get that, is there? I've never seen anything online where you can get your date less insured. Do you know
I
of any?
think that the easiest way is calling your local office.
Yeah.
We did that today with 3 individuals who contacted us. And when we were asking questions about their work history and how long were they working, we were like, well, okay, we got to call, because
Yeah.
these could be very different days. Now, there is a way that you can sort of calculate it.
Right.
There are ways to do it, but the most secure way to make sure that you have the most consistent application would be just finding out from Social Security. All you got to do is call the local office and say, what is my date last insured? That's it. That's the magic language, and they will tell you.
Yeah. Although, again, caveat is calling the local office. If you go to the locator, ssa.gov/locator, a lot of the local offices, you're going to get the 800 number, which means you're going to call and you may be on hold for 3 hours. So, and it as easy as it used to be. That's one of the problems is calling the local office is not like picking up the phone, calling a local number necessarily. More and more of the numbers on the if you go to the locator tool, or the 800 number, which is just miserable. I've called it before, and just you're on. They read you all this litany of messages about fraud and about this and about that, and you can do this online. Then you finally get through, and then you'll be on hold for 2 hours. So,
And sometimes what I learned is that they don't really answer any questions.
Yeah.
What they do is that they'll take a message and send it to somebody in the field office, and then somebody should reach out to you. And it kind of never happens that way.
Yeah.
So
Well, this is a problem, and then maybe that's another question is, obviously there's a real issue with personnel. Are the elected representatives? I assume they're aware of it. Is there anything they can do? If the president proposes a budget that doesn't have enough money to add to the staff, what do you do? Where are these people going to come from?
Well, I think that that's going to be one of the first things the new commissioner is going to have to deal with. He just got confirmed on May 7th or 6th. I believe it was May 7th, actually.
Yeah.
And he's going to have to deal with, what are we going to do? What is the budget? Where is our staff? They closed a lot of, under Commissioner Dudick, there were a lot of departments that closed that they had deemed redundant. And so there's a lot of things within the agency that, maybe there are some areas that they're too top heavy with people, and they actually need more people on the front lines, and they need to deploy them. So it's not actually just get rid of staff, it's reposition the people that's already there. And I think it's going to make it already that takes a load off.
Yeah, hopefully. What have you heard about the new commissioner? Anything at all?
Just everything. No, I didn't get to, I know a couple people who did get to meet the commissioner, especially during, the Hill, when they were doing the hearings and things like that. But no, I haven't met him. I haven't heard much of anything, and I haven't really seen anything come down. When Dudick came in, there was a press release. There was, we're going to immediately do this. We're going to immediately do that. Some things I agreed with, some things I didn't, right? But it kind of hasn't been the same reaction. It's already been 2 weeks. So,
well, I know that the commission, the head of Nascar, this gentleman named David Camp, apparently knows or knew Lee Dudick. And was actually speaking very positively about him. I was on a conference call, so he felt that the Dudick had his heart in the right place. Again, if you look at the Nascar listserv, Mr. Dudek is not going to get a whole lot of Christmas cards from people in Nascar. There are some that just really are not, not real happy with him. And on Charles Hall's blog, a lot of people just, they're really being pretty harsh on him. It's a no-win situation. I mean, you're in a situation where you've got, the president, putting having these Doge folks come in to try to, save money. And there's a whole question of privacy. That's another thing. Did you hear anything about that in terms of the issue about, I know that the Doge folks want to get access to all these Social Security records. Do we know where that's at this point? Is that still being
There
negotiated?
wasn't a lot of talk about that during the conference. The only thing that happened during the conference, which I found was a little bit wild, was there were protesters in front of the conference. And I don't know if it was a function because it was in DC in particular, or, but there were protesters at the conference. And again, any commissioner that's going to come in, that's going to make change, is going to make some people angry. But the fact is that Social Security needs change. It desperately needs it. Now, I think the issue is, where do we agree on how to change it?
Right.
And that's going to take time. But that it needs change is undeniable. I think everybody knows that.
I mean, my sense, and again, this is just purely from 30,000-foot view, is, we've got this looming deadline in 10 years, round numbers, where the trust fund's going to run out of money. And it just seems to me that disability is kind of the easy pickings, because there's not like a lobby like you have the AARP for retirement Social Security. It's just a lot easier to basically go after people to make disability more difficult to get, especially for younger claimants. Whether that will be the case, I don't know. But I mean, that just, that's what concerns me is, are they going to just make it more and more difficult, or are they just going to put more effort into the continuing disability reviews to get people off if they come on? So it just seems like, I know that in Congress, I've seen, videos of some of these hearings, and there is a narrative of some in Congress that everybody in Social Security is, basically committing fraud.
Well, it's because the agency pushes a lot of that narrative, right? With all the messages about fraud, every single release paper that comes from them has a section about fraud in bold at the bottom. But the statistics show that it's less than 0.1% of cases are actually fraud. It's very, very low.
I mean, I've done this for 35 years, and I will tell you, in 35 years of it, I mean, I can think of maybe 5 or 6 clients that I felt were really trying to put one over on this. They were successful in putting one over on this, on the system, that, kind of manipulated their medical, or that the judge was just, as one case I had with a judge who was a 98% approval. The case was kind of marginal, and the judge basically approved her without really any, but that's 5 out of, thousands and thousands. So I don't think that fraud is this huge issue. If anything, there are far more people who should be approved that are not, than the other way around. And that's been my experience. All right, Shub has been on before. He's a regular. He's 56. He got approved, which is great. Stage 4 osteoarthritis. I'm not sure what stage 4, but I assume it means it's fairly serious. Tips to stay under the radar. I'm guessing what he's asking about would be how to avoid a continuing review, how to avoid potential issues. What would you say?
Well, I'd say just generally, the older you get, the less likely they will do a continuing review. Continuing reviews are very common for people in their 20s and 30s, 40s. Once, you're getting close to that 60 age, that really starts to stop. The other thing is, as long as you keep up with your treatment, as long as you keep up with your medications and documentation, or that journal, that log, whatever it is that you were doing that sort of helped you get approved at that stage, which is documenting, connecting those dots, keep that up, right? Just have it ready in case they do. A lot of those continuing reviews happen really fast. Like they say, contact us within 20 days, right? And you fill out this form, send it back to us within 10 days. Right. Well, you got it with the mail like 7 days. It's very hard, but that is what stays under the radar, is getting them the information, making sure that they have it.
Yeah, in fact, I just talked to or emailed it back and forth with a client that I won his case a couple of years ago, and he had a PO box, and so he wasn't checking his PO box. Well, lo and behold, they sent him a letter saying we need updated medical. He never got it. Then they sent him a letter saying we're going to terminate benefits unless you provide this to us. Never got it. Finally, when his benefits stopped, he decided to check his PO box. Lo and behold, he sees all these letters in there. He's like, well, I need my money. What am I going to do? I said, the problem is you can file a request for reconsideration, but you've missed the 10 days. They give you a whopping 10 days to ask for benefits to continue. You missed that. I mean, you can reach out to your congressperson, but you're going to file the request for recon. It's going to take 8 or 9 months, and you request it. It's going to be a year and a half before you get in front of a judge. You won before. Presumably, if you've got still got good medical evidence, you're older, you should win again. But you made a mistake. You didn't check your PO box. I said you can't do that. You really can't do that. Something else I would tell folks is if it's physical, keep a pain diary. That's something where you can look back and say back in May of 25, I had 3 really, really bad days on the week of the 10th or whatever it would be. That's also very, very helpful to do. And then the other thing I'll throw this out is working, because if you get the short form, my understanding, and tell me if I'm incorrect about this, but if you don't have any earnings and the doctor's not saying there's any improvement, that's kind of read by computer. It's more likely than not it's just going to be deemed that you remain disabled. If you are working, somebody may look at it, and now you are at the whim of a potential, claims manager or claims specialist who may decide, well, you're working, therefore, even part-time, therefore, we're going to start looking at this a little more closely. I hate to tell people not to work, and especially if you can use your trial work period months. But if your question is, how do you totally stay off the radar? The answer would be, if you're working at all, that raises your risk level a little bit. How much? If you if you use up your trial work period months, it's going to raise it more. But if you're even within that, it's going to raise it some. Would you agree with that?
So I typically, we get a lot of clients who say, I've been waiting now with the agency for X number of years. Now I got to wait a year in federal court, and then maybe it'll come back. And they're like, I got to work. And I said, okay, go give it a shot. I can guarantee you, from what I've seen on your medical records, it's not going to last long. You're not going to be able to do it because I can see from the records what your issues are, and knowing the market, right? I can see that this is not going to work. So go ahead and try. And then what happens is they maybe do it for like a day or two, and they can't continue, or they never find a job because they're incapable of going to the appointments, making sure all those things are done because they have other issues that prevent that. And I think once they try that, they realize, well, this is not going to, I can't do this. I need to rely on something else.
Do you find that I may interrupt you. You got me thinking. Do you find that unsuccessful work attempts are actually a positive as far as evidentiary value?
I think they are in federal court, right? Because I think that lends to credibility. I think that if you've had a significant work history, I think that it shows you've tried, right? This is not something that you've never done. You've tried and you couldn't handle it because of your condition, not because they relocated you, not because the company shut down, but because of your condition. You can't do that. I think that that's pretty strong evidence. And if you tell it in that kind of story, I think that the ALJs and the agency will see it too. If they only see, well, you worked, but then you stopped.
Right.
We don't know why you stopped. Then I don't think that's going to be helpful. I think that hurts. You need to make sure that you're telling that story about why and how it's connected to your disability.
Yeah. And then that kind of gets to something I'm a big believer in, that is to always have a narrative. We're hardwired as human beings to listen to stories. And so have a narrative that explains, like you said, like Adriana is saying, if you are trying to work and you only last a week, why? Why did you only last a week? What actually happened? Get a coworker, somebody who was there who observed you, have them write a statement. that talks
Yeah.
about what happened. I mean, make this a story so that you're letting the Social Security know, the agency at the administrative level or the judge, or, just let them know this is what actually happened. And I'm trying. I'm really trying. I don't want to be here, but I'm trying, but I just
Yeah.
can't. I tried. It just didn't work.
And you're in charge of your own story.
Yeah.
So make sure that you tell it. And I think it's real important.
Yeah, yeah. Although I do think that, as an attorney doing hearing work, part of what I do is when I talk to my clients before the hearing, I try to get that story. I try to, so I can include that in the brief, include it in my questioning so that, they're telling their story most effectively. And again, if they've got trial work period or unsuccessful work attempts, that's part of the story. If they've got, severe medication side effects,
Yeah.
that's part of the story. You know, and even if it's the point of asking people sometimes, I don't know how much this helps, but I think ask them how frustrating has it been not being able to work, and have them talk about that their friends were all there. They're much less, they don't have any social life now, and they feel like I'm a failure, I don't have any purpose in life. That's part of your story. Tell that story, let a judge know, because I'm a very strong believer that you never want to go in there with the attitude of entitlement, like I'm disabled, pay
Yeah.
me. You want to go with the
Yeah.
idea, I hate this, I don't want to be here, this is embarrassing, this is not who I'm at. I'm a hardworking person. I've worked since I'm 15 years old, and not to be able to work is just devastating to me on so many different levels. That's part of your story,
Yeah.
if it is, that's the case. Um, okay. Kevin Johnson says, I was denied at recon. Up next is an AOJ hearing. It looks like they did an RFC and grid rule for 25-year male instead of 59-year-old who needs knee surgery. They want to change everybody's onset date. Anybody? Okay, we'll come back to that in a second. So what he raises here is that I'm not sure the business about the RFC, and that stands for, by the way, residual functional capacity, which is a legal term. It's not a medical term, it's a legal term. And it really, what it means is, what capacity do you have left over? That's residual after you factor in your medical issues. And grid rules, the grids don't apply when you're 20. They only started really applying, actually there are a couple that apply from 45 to 50, but for the most part it's age 50 on. But he does raise an interesting question is, and I don't know if you see this in your practice, changing of onset date. Are you seeing that where you're seeing Social Security or judges approve a case but change the onset date to eliminate past due benefits? Is that something you're seeing?
I think that people try and change the onset date to make it as easy
Mm-hmm.
to award benefits as possible, right? If you have somebody who at 50 is going to be found disabled no matter what because of their condition at 50, they're going to be found disabled. And you have a time period where they ask for disability or claim that they became disabled at 49, at 48. Well, you're missing out on those 2 years of back pay potentially, but you're potentially better off with adjusting that onset date to what is the easiest day to be
Yeah.
found disabled. Um, when it gets to the federal court aspect of it, those are cases that usually get approved, right? At some point, you're negotiating, you're going to approve it. When it comes to appealing a partially favorable decision,
Mm-hmm.
that is Pandora's box, right? So say you didn't take the onset change, okay? And they say, well, okay, you were not disabled prior to turning 50, but at 50, bam, you became
Right.
disabled. And then people say, well, I want to appeal it for that part in the end, part in the beginning. Well, that opens up a lot of worms because, well, they found you disabled. So now we're saying, no, but that's right. But we're saying this is wrong, but it's connected, but it's not. It becomes a very big issue. Then if it gets remanded at federal court, it comes back. It is possible they shouldn't do it, but it is possible that they reopened the whole time period. And
Mm-hmm.
therefore, you could lose any benefits that you were entitled to
Yeah. Yeah.
as of that time. And they could just change it and say, well, you're not disabled now. So it's a really tricky scenario to kind of play a game with Social Security on what is your onset date. Look for what makes sure that you're still covered under that DLI and your alleged onset date. Make sure that those two match up when it
Mm-hmm.
comes to SSI, you're not going to have that problem, right? SSI is prospect, it's in the future, it's not dealing with anything in the past. So as long as you are found disabled, great, you'll get those benefits. So I think it just look to see where you can make your strongest case to get approved, and then
Yeah,
move
no,
on.
because I see it. I mean, I'll have cases where people are approved at the administrative level, initial recon, but they cut out, years of past due benefits. And, do you appeal that? And my thought would be, if you're looking at $30,000, $40,000, you got to really think about it. If you're looking at, 3 or 4 months, probably not. So it's a tough call. And I've had a couple of hearings this year where I've tried cases where my client was approved at initial. The important thing to, as Adriana points out, there's, it's not like you absolutely are going to get the approval as of the date they gave you. It's a completely new hearing. So you could get a judge 15% and you could be denied. So even though the state agency approved you at age 50, a judge could say you're not disabled at all. I've not seen that happen, but it theoretically could happen. I've had a few where
I've
I've
seen it
appealed the
happen.
onset. Huh? You
I've
did have
seen
it
it
happen?
happen.
Okay.
And we're going back to federal court because it
Yep.
shouldn't have
Yep.
happened. But that's the thing.
Yeah.
Social Security can most times do whatever they want,
Yeah.
right? And then it's up to you to keep pushing forward. It's up to you to keep that case alive.
Yeah.
So do I anticipate that's going to come back? Most likely, because that shouldn't have happened.
Yep.
But it did happen, so now they're not getting anything.
But it's very stressful for the client,
Oh
obviously,
yeah.
to deal with all those. Yeah, and I honestly, when I tell people, if somebody calls me and they're saying, well, I want to apply for benefits, I want to quit my job and apply for benefits, and I'm 49 and a half, I'm going to tell them, hang out until 50, because there's a pretty good chance that, you may be approved as of your 50th birthday, assuming it's musculoskeletal and you meet the grids, or you're 54 in 3 months, get to that next, milestone birthday, 50 or 55, because there's a good chance they're going to change it anyway. So you might as well work and make the money, as opposed to, if you possibly can, as opposed to hoping that Social Security is going to pay you the extra. Because they're looking for ways to save money. That's kind of an overall theme. They're looking for ways to save money, and cutting out past due benefits is a really easy way to do it, because they put you in a situation. Well, do I accept this? This changed onset date, I get ongoing benefits, but I'm giving up $20,000 of past due benefits. What do you do? If you really need the money, well, I'd rather, bird in the hand's worth two in the bush. So, it's in fact, I had a case this year where we won it. I mean, at a hearing, the judge changed the onset date, no past due benefits. Of course, I didn't get paid either. My client was very apologetic about it, but I said, look, we looked at it for appeal, but it just there's really nothing that I felt was really, really strong. Like, what? That's just the way the ball bounces, and write me a nice review. What can you do? What can you do? Okay, so let me ask about Steph. Stephanie's another attorney. I've had her on here, a friend of mine. I don't know when her live. I know she does it in the afternoons. I don't know. You might check on her YouTube channel. Rodney's one of our longtime clients. Good to see you, Rodney. And he actually won a case in front of a really, really low-paid judge. And I can't take credit for it. It was another attorney in my office won the case. And I'm like, you know what? That's one of the few I've heard this judge ever approving. So, that was good.
Wow.
Yeah, that was awesome. Okay. Do you know whether somebody has to have 20 credits the last 10 years to continue to receive benefits after you receive it, or is it only required to be received? I think this is only, you've got to be, again, when you work and you earn credits and you stop working, typically your date last insured will be within about 5 years after you stop working, assuming you're working full time and you're over a certain age. But once and this is I don't know the answer to this question. Let's say you're on benefits for 10 years. Does that toll the date last insured? I don't know the answer to that, in terms of, if, let's say, then you go back to work or whatever, then you go back to try to get on disability. I don't know. I mean, does that make any sense, man?
It does make sense, and I don't know. That is something I've never seen, right?
Okay.
Because the whole idea is that the day last insured is just so that you have to be found disabled prior to that day in order to get disability benefits. So you're then on disability benefits.
Yeah,
So
yeah.
you were disabled prior to
Right,
that
right,
date.
right. Yeah, you
Now
won't
they
get
can find
you don't get credits from being on disability, if that's what you're asking. You don't get earnings credits
right,
for being on disability.
right. So interesting, but
Yeah,
I hope that answers the question.
yeah, I don't know. It's a little unclear, but I mean, the bottom line is that, it's as of the date you're found disabled as of something called your onset date. You've got to be insured as of your onset date. Maybe is a good way to put it. After you're found disabled, your date last insured expires, but you're grandfathered in. You don't lose your
But
benefits because you're date last
It
insured.
it's not about a date last insured at that point, it's about what is the date that you became better, right? So
Yeah,
if it is a case where you've been approved prior to your date last insured, you've been getting benefits. They then say, "Well, you're no longer disabled." It's not the issue does not go back to your date last insured. The issue starts with, "Well, we say that you got better as of this day."
right,
And now your claim is all about how you didn't get better as of that day.
right,
And
right.
that is the issue. It is not whether or not you were disabled prior to your date last insured.
It reminded me of somebody. One of my clients. I got a call. I just made a note to give her a call. This is a very interesting case. This young lady got very, very sick. I'm not going to go into detail, but she got very, very sick and was disabled, truly disabled for several years, and then got better to the point where she went back to work. And we were trying to argue. I was trying to argue with a very reasonable judge that her disability. At least try to argue that her disability continued and that the work she did should be considered trial work period. Judge basically just said, no, medically she got better. And she emailed me the other day and she said, well, I'm working, but I'm having more and more trouble working. If I stop, can I ask for benefits to be reinstated under the extended period of disability rule, which I'm not that familiar with. I mean, I don't see it very often, but basically I think it's a 36-month period after your benefits stop that you are in what they call an extended period of disability so that you can get back on a little more easily. So I've got to do a little research on that, but I just realized I needed to give her a call because I had not responded to her yet. So I made a note. Roy's Place. I received a letter saying I may get a review to see if my medical situation is the same. Should I send in current QME? Not sure. I don't know what QME is. I'm CT scans, EMG or not. I'm turning 60. What point should I hire a lawyer? I mean, I would say, if you're on benefits, you said you got a letter, you may get a review. Wait till you get a review. I mean, I'm not a big fan of necessarily giving Social Security something they're not asking for yet. I mean, have
I
you heard
mean,
of this?
I would start gathering it just to
Yeah,
make sure
right,
that I know what's going
right,
on, right?
right.
So there's sometimes a lot of things. One of the big things that we see is that the claimants don't really know what their medical records say,
Hmm.
right? And that will remain true even if you're getting disability, still going to the doctor, and you're not seeing those records. So I would start getting those records, and as you said, keep that journal, keep that log, keep
Yep.
all of your information and start gathering that because you're going to have a very short window in which to provide that information. But I wouldn't just send it to them because where are they going to process it?
Right. Where are you going to put it? Right.
There's no barcode, nobody has your
Right.
case. There's nowhere to send it to,
Right.
right? So the better course of action would be start making all that stuff for you. Start gathering all your information, knowing that, okay, I may get a review letter. If I do, I got to answer quick and I already have everything.
Yeah. In fact, what I would tell people, what I tell my clients to do, whenever possible, I said, look, I'll send you the exhibit file. It's in PDF format. It's something that can be emailed
Yeah.
to you. Keep that someplace secure so you've got all these records up until a certain point, and then download stuff from your portals. One of the things I will say that I've seen one of the biggest changes I've seen in this practice area over the many years I've done it is it's gotten much easier to get medical records. It used to be you had to send away form by mail, pay for them, all this kind of stuff. Now a lot of practices have portals. There's this whole what's the HIT,
The
health
high tech,
information technology,
yeah.
high tech, which is another way to get them. It's a lot easier to get medical records. And as Adriana says, you should have your own file. And the starting point would be the exhibit file from your case. Again, that's going to be a PDF. You can get that from your lawyer, can get that for you. I'd also tell you, if you go to a hearing, get the audio of the hearing. Just keep that. That's just, it's information you want to have. It can be very, very useful to you. And then, as time goes by, once or twice a year, log into the portal, download the information. If there is no portal, ask the doctor for copies of it. Just be ready, because like we were saying, you may get a letter saying you got 20 days to get all this together. That's not when you want to start. That you want to already have it together, have it organized, because you have to be your own advocate. And honestly, if you have all that information, you won't necessarily need a lawyer, because it's 60. It's unlikely they're going to, terminate you anyway. But the bigger issue is, if you hire a lawyer to help you with a continuing disability review, just filling out forms and responding to stuff, you're going to pay out of pocket. There's no, lawyers in this area, we get paid a contingency if we're trying to recover past due benefits. But if you're asking for a service, a fee-based service, that's going to be something you'll have to pay for. Maybe that's okay, but if this is something, it's a matter of gathering medical information and putting a stamp on it and sending it in or faxing it someplace, just do it. I mean, why pay a lawyer to do that? That doesn't make sense to me.
Yeah. And I will add one little caveat. I know how you had said to get the hearing get the hearing recording, right? And keep that. Nowadays, you could also just put it in an AI service, right?
Yes.
And it can make a transcription for you. And if you need that to show your doctor for any reason, you need to show that your therapist that for any reason, that could be something that's helpful, right? It's going to be hard for them to sit there and hear the 1 hour audio or whatever with all the stuff that happens with IT.
Right.
But AI could quickly and easily and very cheaply make the transcript for you. And now you have papers that you can now give to your doctors if you need to review. This is what they said. And you can say, well, has anything changed? And, this is what they said, and this is why it's still the same, right?
Absolutely. Speaking of AI, is your firm, are you using AI in your practice at this point?
So AI is still a little bit iffy, right? Because it's still open and all that stuff. What we do, at least what I do really, is I say, this is what I'm trying to say, right?
Yeah.
I don't know why people aren't getting it. Help me make this better. Help me make this more understandable. I think a lot of what happens is that for those of us who do disability work, we live and breathe this every day, right? So I can look in a case and be like, this is the clear error here, right? But then for some reason, there is a new judge who maybe hasn't done Social Security very long, and I'm talking about something like everybody knows this, but if you're not in this all the time, I guess maybe you don't know it. And so it's one of those where I'll say, help me make this better. Help me clean this up. What are my top points? So that's how I've been using AI in the practice. And I know a lot of people have been doing some great things with it. One of the presenters who I assisted with at the presentation in Nascar was all about using AI and having it digest the medical evidence and the medical records and things like that. I think that that's also very helpful. I think that when it comes to the district court phase, what I'm looking for is the things that maybe AI won't be picking up, right? So I need to really have an eye on each and every single page to see what are trends that I, as a human attorney, trying to figure out what am I looking for? What is the story that I'm telling? Do I think AI will get there in maybe a couple of years? Yes, but just giving me a summary of, this is what happened at this visit is not enough when I'm looking at trends for something else.
Yeah. Well, what we're seeing a lot of it at the hearing level is there are a lot of services now that will take medical, exhibits files and will kind of summarize that or create a chronological log, which is actually very helpful. In fact, there's a service that I use called Assure, which is, there are a couple of them that are out there. One's called Chronicle, one's called Assure. I use both of them that will basically download all the exhibits from the Social Security file. And these are all, HIPAA compliant and all that, but they'll download the exhibit file. Then they will use an AI tool to kind of summarize the medical or to create chronologies. And, it's not perfect, but I will say when this started happening a couple of years ago, it was pretty rudimentary. It really didn't do a very good job. It's gotten a lot better. I mean,
Yeah.
scarily so, a lot better, to the point now where you can use it as a really strong starting point. And again, I'll look at the underlying medical record. I may see that it didn't pick up something that I thought was important, but I'm not looking. I remember I had a law school professor years ago say, after you've been practicing law for 10 or 15 years, you should never look at a blank piece of paper. And I thought
Yeah.
that was kind of a very interesting way to look at it. But he was right. Is you should not be looking at a blank piece of paper. And now with what AI can do is it can give you kind of a really good starting point to understand your file. You still have to you have to read through it, but you can skip over certain things, and you can
Yeah.
you can like I use Adobe Acrobat. It has a search functions. Everything's in PDF. I can search for MRI, or I can search for Dr. Morrison, or I can search for whatever, and it'll take you right there. And that's been very, very helpful to me. One thing, and I mean, see what your thoughts on this would be. I can't imagine that it's not going to get to the point where Social Security will have certain models of what they perceive to be viable cases. And again, what I
Mm-hmm.
do in my head, what you and I do in our heads. Okay, we have a 57-year-old with a herniated disc and nerve root impingement at L5S1, and disc compression or stenosis at L4-5, and and reporting numbness and tingling into the left leg and weakness. You're going to look at that and, okay, mentally, okay, that's a pretty strong case. Are we not going to get to the point where Social Security is going to use those same criteria and have their own criteria internally to evaluate cases? I mean, it seems to me that's inevitable.
I think that's going to happen, and I think it's going
Yeah,
to be sooner
yeah,
than we imagine,
yeah,
really. And I think the issue is who's training that AI,
yeah,
right?
yeah, yeah,
Like what are they inputting into that bot to make it spit out, this is the analysis. I
right,
think it's always using AI as a tool is great. It is not a replacement.
right,
So that is the only, caveat to all of it being used, is it shouldn't be a replacement for things.
yeah,
So, I mean, how this continues to develop will be an interesting,
yeah.
it'll be really interesting.
Yeah, no, I think, I mean, for whatever it's worth, I think that the go-to job in the next 5, 10 years is going to be a prompt engineer, where
Yeah.
you learn how to query. I mean, sure, because the key with AI is to know how to ask the question, and
Right.
you have to be able to, ask the question in the right way so that AI will tell you what you want to know. And I've seen some examples. There's some really mind-blowing things on YouTube, nothing to do with the law in particular, but just there was one guy, I can't remember his name off the top of my head, but he was just giving examples of how the way you answer questions and the way you put certain sources in and information that you want the AI to consider. It's just like, this is pretty incredible what this will do. And I think, again, there's a lot of hype, and some of it, I'm making $10,000 a month, on autopilot using it. Okay, I'm sure you are, but
Yeah.
it is I think it is as groundbreaking, technology as getting the personal computer was back in the 1980s, or the internet was in, the late 90s or early, 2000s. I think it's just an incredible technology. Again, it's a tool, but I mean, it is, it sort of grows on itself. And I think that, they're going to be, which will be interesting to see, because there are going to be certain jobs that are going to become no longer because of AI.
Yeah.
You know,
Do
you know,
you
you,
remember when the first iPhones came out
yeah,
and people were like, "Why do I need all that? Why do I
right,
need all that on the phone?" And turns out now we can't live without them.
yeah, yeah,
So it's just in a matter of months to a couple of years, this is going
yep,
to be a completely different conversation.
yeah. It really will be. It's just very, very interesting. And like I said, I'm expecting at some point, especially because of the, I think just, what if Elon Musk is involved in it, this is a guy that really is really into technology. They're going to develop some AI models to evaluate cases, and that may eliminate the need for certain human beings at Social Security. Now, again, judges are still going to be judges, but at some point there's going to be some of it's going to become a little more automated. So It's going to be an
Yeah.
interesting few years. So we'll see. All right, Tara. Hello, Tara, one of our clients here. Okay, let's see here. Jen is my parent. It's another thing about what's is really amazing about just, with post-COVID, everything going remote. Jen is my main paralegal. She's in Nebraska. I'm in Atlanta, Georgia.
Hi, Jen.
And we have never met in person. We've talked on the phone, we video chat, we talk all the time, but we've never met in person. And in fact, I got an email, Jen. I'll tell you since you're there. I got an email from my former paralegal, someone who worked for me 20-something years ago, whose daughter is now working for me remotely. They're going to be in town in a few weeks, and she's like, let's have lunch. So I haven't seen her daughter since her daughter was in high school, and she does some work. It's just a crazy situation where you're dealing with people that you just never. I mean, you and I've never met in person. Yet we were having these conversations. Hopefully we will at some point in a Nascar conference. But it's crazy.
I love that. I think that's so great.
Yeah, no, it is. I think it's really changed quite a few things there. Just the way we interact. I mean, lawyers in, like I said, in this area, I happen to think are fairly cooperative in terms of working. Everybody, people will share information and help each other. And I think that, I think it's somewhat unique in the Social Security bar. I think other areas are not quite like that, but it's just interesting. You become friendly with people that you've never met. And, if you think about 15, 20 years ago, it's just not likely that would ever happen, but it does now. So,
yeah.
Okay. Mark is one of my clients that we proposed new compassionate allowance. Could you talk about listings get updated and when? Okay. Well, that's maybe a question for Adriana. First of all, I don't know. I mean, it's interesting. I guess that makes sense. If you're proposing a compassionate allowance, you would send it to Social Security. I don't know what the procedure is to get a condition on the CA list, but I'm guessing that they would take proposals from anybody. I don't know, but why not?
Yeah, I don't know. I mean, who did you send it to? That would be, I think, my first question.
I don't know. I mean, maybe it's the Social Security in general. I mean, Mark's a pretty bright guy.
Yeah.
We've had some very interesting conversations. So, I suspect he looked up. But yeah, I think there's no reason not to send it to them.
Yeah. What's the worst they say? No?
Right.
Well, it's not out there right now.
Okay. And let's talk about, he asked about listings, how to list, and that's a very interesting question. I don't know the answer to. They do update the listings periodically. How does that work? Do we know how that works? Or is it just sort of this black box in Social Security where, somebody decides that is in charge of updating the listings and they periodically run it through a procedure? That's how I'm guessing it happens.
Well, I think that they keep track of everything at Social Security. They keep track of how many approvals, how many denials, what listings were approved, how many times was that listing cited for a reason for disability. And so I think that has a lot to do with how listings get updated. I think evolution of medical records and technology also changes how listings get updated. The two major listing updates that I think we've recently lived through was when they updated the mental listings, right? When they were looking at depression and anxiety in those listings. And then more recently, within the last, 5-4 years, where they updated the musculoskeletal listings, right?
They made it more difficult.
They made them more difficult. Could it be that they started tracking how many people got approved because of these and the remand rate based on this listing as opposed to this listing? That's one of the reasons. But if you look at it, the last two major rehauls were both probably the two
most
common listings for disability. So, I mean, I'm not saying there's something there, but maybe there's something there.
I think there's absolutely something. I mean, I think that they see a lot of approvals on these, and so they're going to make it harder. And look, I think it filters down. I mean, I of the belief that if you're applying for disability and your condition is in the listings, even if you're not listing level, you're already at a better place because Social Security has already told us we consider this condition potentially
Mhm.
disabling, right? Whereas fibromyalgia, let's say, is not in the listings. So you're going to have to go beyond. It's, you're going to have to really go further to explain why this is disabling. Back pain, depression, certain cardiac issues, certain breathing issues. These are in the listings. So by definition, they are perceived to be fairly serious. But I think at the same time, when Social Security makes that musculoskeletal listing more difficult, that's also telling judges that you want to be a little more demanding when it comes to finding a less than sedentary functional capacity, because we're assuming, right or wrong, that people can work with a little more damage to their spine than maybe we thought they could, a few years ago. And maybe that's a reflection of medical technology. There have been improvements in physical therapy, nutrition. I mean, you read about, these advances where, people have been, certain conditions have been cured. There was just one the other day where CRISPR, which if you're all not aware of what that is, this is a revolutionary, it's still very, very new, but gene editing, where they can go in and edit a gene to eliminate certain, congenital problems. It's pretty mind blowing. So, you could be born with, I don't know, let's say, I don't know, I can't think of it off the top of my head, but just a genetic disease, and CRISPR goes in there and modifies the gene, and so you no longer have that. That will filter its way into Social Security, not for many, many years, but
Yeah.
there's been practical, uses of this.
Think about surgery, right? A knee surgery.
Yeah,
A knee surgery 15 years ago is
yeah,
completely different than a knee
right,
surgery now.
right,
So, and when it comes to medication management as well, there are a lot of things. Now, one thing that would be interesting is, are they going to make a listing for long COVID? I think
yeah,
that's going
yeah,
to be something that, it's one of those softer diagnoses,
right.
right? Because it's more based on ruling out other things, and then, what are your symptoms? But, that's gonna be something that's gonna affect a lot of people moving forward.
Oh yeah, yeah. What is in your firm? What do you look for in long COVID cases, and what do you find that works? If you have
Well, we
any,
loo I think long COVID is very similar to anything like fibromyalgia or Ehlers-Danlos syndrome, anything where you're looking at consistency. You have to show that you've been going to the doctor and you're complaining about the same things. As long as that is, consistent, I think then you're in a much better position. It's when they maybe don't go to the doctor saying, "Well, the doctor's not gonna do anything for me."
yeah,
I know that. You
can't
know
do
that.
that. You can't do
The doctor knows that. We all know that, okay?
that.
We all know that. But that's still, you still have to go in and complain to that doctor,
Yeah,
right?
yeah,
Because maybe something changes, maybe something happens, or maybe you get worse,
yeah,
and that needs to be documented. So what we look for is treatment. You have to get treatment. It has to be pretty consistent.
yeah. I found that the two areas where it seems to be most productive would be, breathing issues and cardiac issues. Those seem to
Mhm.
be the ones that move the meter, at least for my cases. I had one recently where my client, actually got really sick. And this was a very high achieving guy. I mean, PhD level, and he had a really high paying job. And he took the vaccine, and he had a really, really bad reaction to the vaccine. Then he took a second dose of it and had an even worse reaction. Then he got COVID, after the
Oh
vaccine,
my
and
goodness.
it just, destroyed him. And he was going to,
Yeah,
a clinic like in, halfway across the country, somebody to deal with all this stuff and all these different procedures. Nothing has really worked for him.
yeah,
But, that was, it goes to your point, and that is that, he was just looking for treatment and trying everything he could possibly try, and, constantly going to the doctor, even though there wasn't much they could do for him, but he was desperate to get back to work. Because again, he was making well over six figures, really high level position, highly educated guy. And he's like, I don't want to be sitting at home, but
yeah,
it's tough. But Mark, yeah, it'd be interesting. Maybe something we can talk about is, I'm curious as to where you submitted it. Number one, and number two, what
yeah.
kind of response you get, what they say to you, and then as far as the listings updated, I think what Adriana is saying is that Social Security, that they have a lot of statistics that we don't have access to. Like, for example, I would like to know what percentage of people over 55 are approved versus people
Mhm.
under 55 or under 50, if they break it down by age. I'm sure there's that
Oh, I'm
data available.
sure they have that.
Yeah, but actually might be a Freedom of Information Act thing to do to find that out, because that would be very helpful to know. I mean, we
Yeah.
know. I mean, we know the answer to it's going to be much higher, but is it 75%? Is it 63%? That we don't know, because all we get this waterfall chart that kind of gives us an overall 49% of cases at hearing are approved, and I don't think it even breaks down between fully favorable and partially favorable, but yeah,
No,
that
it
may
just
have
says
all.
approval. It just says approval, dismissed,
Yeah,
or, denied, right?
right, right,
So,
right. And we don't know, of the cases that are denied at initial, what percentage of those cases are actually appealed and go to recon. So what percentage of people give up? I mean, again, there's a lot of stats they've got. They don't tell us. Um, but yeah, I think what you're saying, and I think I would agree, is that there are probably people that do analytics for them that determine what medical conditions seem to be moving the meter with judges and with adjudicators, and some of those will be added to the listings, or the listings may be modified to reflect new treatments, new surgeries, new medications. Like, I think your example you gave is a really good one. Knee surgery, hip surgery. I mean,
mhm.
hip surgery. I mean, my wife's grandmother had hip surgery. 50 years ago, she was like in a full body cast for like months. You know,
Yeah.
my, I got a buddy of mine who says he may be listening tonight. I don't know. I play tennis with him today. And whipped it behind. We'll just leave that for the side. But anyway, he had hip replacement surgery, and he's back playing tennis. So it just we just it's pretty incredible.
I will
Vince,
say that it is interesting when they do propose a new rule or they're
yeah,
going to change the regulations, they do ask for comments. They
yeah,
do ask for what are the thoughts, and anybody can submit
yep,
anything
yep,
when they do that. So that's also a way to get involved within changing, how the agency does things.
yep, yep. Absolutely, absolutely. Um, all right, Tara says hello to Jen. Okay, Scott says my ALJ is a 49% approval. That's kind of right, sort of right down the middle. I mean, don't you think?
Yeah, seems like that's pretty fair judge.
Yeah,
If
yeah,
the
that's pretty good.
average, if the national average on approvals is about 51%, that feels that this is going to be, a fair hearing.
Yep, yep. In fact, a friend of mine, Chad Brown, he made a very interesting video, and he said that he feels like the judges that are, let's say 45% and higher, are usually going in looking for a reason to approve. Not that they're going to approve, but they're open, very open to it. Obviously, the higher they are, they're looking for a reason to approve. You get below 40%, they're going in with the idea, I'm going to deny this, and I'm looking for a reason to deny. I never really thought about it that way, but I think every judge has in his or her mind an idea of what it takes to win, a back pain case or a diabetes case or a kidney disease, whatever it may be.
Yeah.
And, that internal voice they've got, and then those internal criteria are going to really, be reflected in their decisions. We don't know what those voices are saying, but, the approval rates will kind of give you an idea. But I think a 49% approval is pretty that much down the middle. That tells me this is a judge who, is, if you're over 50, that's probably a pretty good shot that you're probably, because the reason that's as high as it is because they're probably approving a lot of people over 50, but it's also a judge that's going to be open to a reasonable argument. So I think all in all, that's not too bad. All right, Stephanie says, I thought I had called you, Stephanie, but I'll double check, and if we owe you a call, then you will be called. All right, Kevin is in Tennessee. In fact, let me make a note for Stephanie. Jen, if you're still watching, make a note when you call Stephanie. I was get some business done here, right? Yeah. Okay. How come? How does let's see? Does does SSA send us letters working part time? Well, again, Michael, what they will do is they will send you. There's something called a short form and a long form CDR. Continuing disability review. And the short form is like 5 or 6 questions. And one of the questions is, are you working? You've got to show how much you're earning. And the other one of the questions is, has a doctor said to you that your condition's improved, or have you gone to the doctor? It's just like 5 questions. And then the long form is a much more detailed questionnaire. And generally speaking, again, very, very generally speaking, if you've used up your trial work period months and you're working, but you're still under SGA, and you get that long form, that's where I think you run into a little bit of risk. I don't think Social Security wants to discourage people from working. So if you're working and you're within your trial work period time, they may note it, but I don't think that's going to trigger a CDR, because otherwise people would never try to work, and they want people to try to work. But I think once you used up your CDR, your trial work period months, even if you're under SGA, I think you're going to have somebody look at that a little more closely, because the presumption may be that, well, if you're able to work at, let's say you're making $1,500 a month, you're under SGA, but are you possibly suppressing your income? Could you do more? So I think that's where you run into some issues there. I mean, I don't want to overthink it, but I'm just logically, that would be, given that there's a concern about the budget and about the trust fund, that would make sense. All right, Andrea Minier. Hello, Andrea. Mark is back. Dark hypothetical. Okay. Well, Mark, please don't pass away. If I know that's very dark, but okay. What happens to a case that have passed away with a case in limbo? I would think, I don't know. I mean, I know I've got cases. I've got one coming up with a client who passed away waiting. So I'm guessing that the death of a claimant in SSD, an SSI, if you pass away, your case is over. But
yeah, that's it. Because there's nothing that there's nobody that they can give the benefits to. However, when you have a claimant on Title II, so you're on disability insurance benefits, if their claim is pending, you can substitute the party for a spouse, a child, or something who would be eligible for those benefits and that coverage.
Would that also apply to the appeals council and district court?
Yes, it does apply. We do those cases as well, where it's the person's name for the deceased person, right? They apply as a substitute beneficiary, and they would be they go to the hearing, right? If it comes back on remand, the surviving spouse or whoever was the substitute party will then have that hearing with the judge. The issue is still whether the claimant was disabled, right? The deceased person was disabled. It's just now being brought as a substitute party. So it still happens, and they're still around, just not SSI.
I think it happened I think there was 55,000 people that died, either last year or the year before waiting. I mean, it's not an insubstantial number. And, my experience, I will tell you is, if the person passed away because of the condition that they're claiming for disability, that obviously makes the case a good bit stronger. If they passed away, let's say the person had, back pain and they passed away of a heart attack, or they were killed in a car accident, God forbid, different story. But, most judges, my experience has been, are pretty sympathetic to the surviving, whether it's spouse or children or whatever, because they've obviously gone through a lot. All right, Andrea asks, looks like she's got a German Shepherd there in her little icon. Okay. I don't, sometimes I have my dog down here, but she tends to be a little distracting, so I didn't bring her.
Wait, what kind of dog do you have?
I have a 75-pound golden doodle.
My goodness.
Yeah, she was supposed to be 35 pounds, and needless to say, she is not. But she was actually bred to be a service dog. She has 2 sisters that are service dogs. One is for a young lady who's got epilepsy. So the dog will sense, Nova's the name of the dog. Nova will sense that this young lady is about to have a seizure and will get under her. And then there's another sister who is a psychiatric service dog for a young woman who's got some psychiatric issues. And I guess the dog is kind of a, support dog. And
That's
they're
wonderful.
Yeah, it's kind of cool. So
I love dogs, so that's why I just stopped.
My dog was she was part of a litter. Obviously, I think that goes without saying. She's part of a litter. She wasn't immaculately conceived, and so they took several of these dogs, because they're bright. I mean, golden doodles tend to be pretty bright, and Sadie actually happens to be a very smart dog, a little mischievous, but they took her to a training in Alabama. There's a woman who does training, and they just felt like she was a little too excitable, and that is true. I mean, like the door will, somebody will knock on the door, or she'll hear a car coming up, and she just goes crazy. I'm like, it's the same, it's the same, the same person coming, my wife coming home from work. It's, but she goes kind of crazy, so she gets a little excitable. But she's very
adorable. I love it.
She's very, I mean, she's very smart dog, and she's very, very sweet. And doesn't know how big she is sometimes. That's the only issue, because, like I said, 75 pounds. She's a bit of a load, but she's a good dog. And we take her. We have fun. She's fun to kind. She likes to wrestle, and she likes to play, and so she's good. Okay. But this is not. Let's get back to Andrea's question. Can you ask for special consideration during recon? Financial hardship, like not having houses. Yeah, there is something called dire need.
Mm-hmm.
My experience is, however, that it doesn't really do much anymore. I mean, I don't know if you're seeing the same thing, but dire need, in theory, if you are about to be homeless, you're about to lose your car, you're living in your car, and you can put that in, you can submit a letter to Social Security asking for dire need. I find that asking your congressperson to get involved is a much more effective way to get things moving.
Yeah. Because if they're looking at dire need, they're looking at that you can't even get into a shelter.
Right.
Like that's a pretty high, difficult standard. And then you need documentation of that. It's not just you saying, hey, I can't get into a shelter. So the congressman is probably the best way to go.
Yeah. I mean, I think if you had, if you have notice of foreclosure, you have, but again, a lot of times those things happen before you could get to a hearing. So they've got to give you a certain amount of notice, even if you waive notice, getting on a docket, maybe 3 or 4 months. So, again, it's something that you can try. Back in the day, dire need meant something, but now I think everybody's heard of it. So everybody does it. And I think that, right now, if you're 100% VA disabled, that'll get you expedited. If you are having a congressional inquiry, that'll get you expedited, probably more so than dire need, I would think. So, Andre, I would say, I would probably tell you, reach out to your I think senator. I typically prefer senator as opposed to representative, because they have people that just do Social Security. Reach out to your senator and explain that you are in a really difficult situation and you need this thing to be processed more quickly. All right. So, Mark, I think we already answered your. Okay, does it stay open? It does stay open. Corlil says, good evening. Good evening, Carlil, I'm sorry. And Cynthia says, don't forget the like button. You please hit the like button. That would be much appreciated. Get a case evaluation. I got the crawl going, but yes, if you want a case evaluation, please do that. How long does it take to get the necessary points full-time? Because again, I think it's going to boil down to the earnings. I mean, you've got to have 20 credits in, 40 credits in 5 out of 10 years. So you've got to have 20 credits in the last 40 quarters. Unless you're younger, if you're like in your 20s, you don't need to have as many. But you're going to need to work for at least, if you're in 50, let's say your 50s, you're going to need 5 years of work to get the quarters. And I think I know why Mark's asking that. Because of the date less insured issue. But yeah, I think you've got to generate. And like I said, the way it works is in 2025, you get 4 credits for $7,200, $7,240. So if you were to work in 25 and earn $7,200, $7,300, let's round it up, and then in 2026 earn another 7,500. And then in 2027, another, 8,000 or whatever, that would probably get you back to being insured. But you got to look at it. It's a rolling 10-year period of time. And so, you can kind of figure out what you need based on your My Social Security statement, which, by the way, is another pet peeve of mine. When you apply for benefits, you cannot access your My Social Security statement. Any idea why that would? It makes no sense. It's like they're saying, we're going to hide from you information you really need.
Yeah.
I don't know. Okay. No Sky says, good evening. Hello to No Sky. Okay. Corlil says, I have a comprehensive internal medical review coming up. What do they want to know? Do you mean a CE, a consultative evaluation? I'm not sure if that's what you mean or not. Assuming that's what you mean, consultative evaluation. I don't know how comprehensive it's going to be. I did a live stream with Dr. John Foster, who's a doctor who does these, and I would tell you to go look at that. Or I've got some videos about those. Bottom line is that they're looking to try to determine if you have any functional limitations. And my experience, and Adriana, maybe you have different experience, the internal medicine ones are sort of useless, is a good way to put it. I mean, they don't really tell you anything. That's from my experience. So I don't know.
I think it would be important if you're having that exam, document how long it was. How long were you with the doctor? What did they actually examine? Did they weigh you, or did they just ask you what your weight is? And then I would get that to my attorney and I would submit something that says, hey, whatever is said in here, it's not going to be very useful.
Right.
Most of those cases are not the basis for an award. They're the basis for a denial.
Yep, exactly. That's exactly right. Couldn't have said it better. That's exactly right. They use those CEs to deny you. Yeah, I remember at the last Nascar in Nashville, Michael Leiner, who's an attorney in Cleveland, he made a very interesting point. He said, you should really write down exactly what you can remember about your CE after you do it. Because
right at that time.
At that time, don't wait a week. Do it that day. In fact, he even has a form. I think he may have sent it to me at one point of what you just, the things you want to write down as to what happened. Did the doctor physically touch you? Did they do a reflex test? Did they take your pulse? Did they listen to your heart? Whatever it may be, because when you're doing a brief, if you have a bad CE report, consultative report, and you can basically document that this lasted 15 minutes, the doctor's on his cell phone the whole time, you can ask the judge to give it little to no weight. And so yes, I think you should definitely write that down. Okay. This is a person who's a regular here. Good evening to you. Blue Z. Okay. How long after you do the auxiliary benefit phone interview to receive your kids' benefits? I think it depends on their workload. I mean, a couple of weeks, 2-3 weeks. I mean,
2 to 3 weeks. Oh, I was thinking months. I mean, I think they are pretty behind on paying and awards. I think that's where a lot of the bottleneck is at the current time. So I would say it's probably going to be months.
Okay. Yeah, that's not reassuring. Yeah, I mean, I've got cases where it's interesting. Sometimes the money will show up like a week or two after the favorable decision, before the letter even comes that explains the benefits. Other times it can take months and months, and then all of a sudden, out of the blue, there'll be a deposit. I got one where the judge denied my fee agreement because it was a prior attorney. The problem was the prior attorney had withdrawn and waived fees, and that was in the file. So I wrote a letter to the regional commissioner, and the regional commissioner basically issued an order saying, pay the fee. So they sent me half the money, and I can't get them to send the other half. And I'm like, so I'm going to call my senator and say,
yes, you should,
to help with this. Okay. The client's a really nice guy, and he's like, he's like, have you gotten your money? Like, no, I haven't gotten the money yet. Okay. Okay. Would a 24-year-old, this is a good question. Would a 24-year-old type 1 diabetic, end-stage renal failure, dialysis, blind in one eye, no peripheral vision in the good eye, and very limited vision, can she get SSI and Medicaid expedited? Again, SSI, expedited is not going to be based on the severity of your problem. It's going to be based on, whether it's financial, dire need, or, congressional inquiry. So you can take steps to move things along. Again, reach out to your senator is what I would tell you. Let's take this one a step further. 24-year-old, but serious conditions. This seems to me like this is a case that's got a pretty good she's got a pretty good argument. Would you agree?
Yeah, I think so.
Mhm.
I would also look to see if any of the conditions qualify under the compassionate allowance.
Yep. Yep.
If it has progressed as far as it could be, then you could look at a compassionate allowance. But I don't think it would necessarily get expedited
Yep. Yep.
any other way.
It looks like it could be a listing level case too. Um, and this is,
Possibly.
yeah, and this is an example. People say, they ask, they have list conditions that said, you think can get approved. If you're 24, this is the level of impairment you sort of have to have. I mean, you're not going to get approved at 24 the same way you get approved at 54 or 58. This is the level of impairment you got to have. I hate to put it that way, but that's just kind of the way it is. All right, sweet candy. How long does it take to hear from Social Security if you file an appeal? Dealing with mental. Well, again, what kind of appeal? Are you filing a recon
Mhm.
appeal? Are you filing a request for a hearing? Are you filing an appeals council request? I mean, you don't really say what you're talking about. I'm assuming that you've been denied at initial, you file your recon. Again, depending on where you live, I'm seeing recon appeals taking 9, 10, 12 months. It just depends on where you live. Now, Adriana's in Florida. Is it taking longer? What are you seeing in Florida?
It's taking about a year
Yeah.
plus at initial and recon,
Yep.
and I don't see it getting any shorter
No, I don't think.
anytime being. But the bottleneck for those kinds of cases is not necessarily Social Security, it's the Department of Human and Health Services. It's the
Yep.
state,
State
for
agency.
here, it's the Florida's Department of Health, right? That is where the bottleneck is. It's not Social Security, but there's a big problem with getting information to DDS, making sure that they get the information from Social Security. They don't give you the information. DDS is not. There's a lot of issues with that, but that's where
Yeah.
the bottleneck is.
Yeah. Well, look, I will say this. I mean, when I started doing this, we had paper folders. I mean, it was pretty. I mean, pretty crazy. I mean, you have to go down to the hearing office and sit there, with a file in your lap and take notes. So they've done good things in terms of making it paperless. And I think there's been a real improvement in accessing medical records, but it's still a very, and Adriana, you addressed this earlier. There's a lot of things that need to be done to bring this into the current century. There's a lot of procedures and processes. The computer systems they've got are ancient. I don't think they talk to one another. I mean, there's a lot of work to be done. I know they spent millions on new computer systems they've had to scrap because they don't work. I mean, you're talking about a very, very, you know, expansive agency with a lot of different things going on, a lot of people logging in, and it's going to be a major undertaking to modernize it. Now, Frank Bisignano, I think I'm pronouncing his name right, the new commissioner, he
I think
comes
so.
from financial services industry. Is that correct?
Yeah,
Bisignano?
he
Yeah.
came from, I think, Chase Bank, JP Morgan Chase.
I think it was in FinServ. At one point he was with Chase, but I
Yeah.
know he's in financial services. But that's the type of person that might be able to really make some improvements in terms of the computer system. The problem is that when you modernize a computer system on the fly, it's hard to do that because
Yeah.
you're trying to, then you got people having to work on two different systems at the same time, which makes it more time, and then you got fewer people. So it's going to be a long process. I don't
Yep.
think it's going to be fast. All right, this is something Mike asked. I think you addressed this earlier in terms of substantial number of jobs, and as Adriana said, it's going to depend, and every judge kind of has their own leeway to make that decision, their own discretion to make that decision. And there's no consistent. There should be, but there really isn't. Is there any sort of consistency within a particular circuit? Let's say the Fourth Circuit or the Ninth Circuit. Do they have uh, any commonality there, or is it really at the granular ALJ level?
I think it's really what the circuits kind of do and what the district courts kind of do is that as long as the ALJ finds that that number is a significant number, that number they're going to say, okay, well, then that's fine. The trick is, say the ALJ comes up with 3 jobs in the decision based on the VE testimony,
Yep.
right? Vocational expert says you could do 3 jobs. Well, one of those jobs is no longer available to that person because of this additional limitation, or it's inconsistent. There's some sort of issue. The ALJ says these 3 jobs, that constitutes a significant number. But if you take one of the jobs away, now you only have 2 jobs. That number, nobody at the agency, the ALJ nor the
Right.
appeals council, nobody at the agency said that is a significant number. That's the argument.
Yeah.
It is not, well, this judge said it's 20,000 and that's not a significant number because look at this other case that said 20,000 wasn't a significant number. That's not going to be a particularly winning argument. So there really is no standard. It is as long as the ALJ finds that it's a significant number, the courts are going to follow.
Yeah. And you actually raised another interesting point, is that at the appeals council level, you talked about this a little bit earlier, they're going to look to see, did the judge draw a reasonable conclusion? They're not going to second guess the judge's conclusion, but is it based on a reasonable, analysis, the way they analyze it? So, you may have, you and I may look at it and say, well, that's the wrong conclusion. But if the judge followed the right process, that's not reversible. But I'm kind of getting the sense that the district court, they may go a little more into the merits. Am I sort of saying that correctly?
Yes, I think the district court will get into the facts and say, well, based on these facts, this is not supported. You can't make this conclusion without this missing link. You didn't explain, and the whole thing is you have to show your work.
Yeah. And that's kind of why, the appeals council cases are denied by the appeals council, but remanded by the federal court, because it's taking a little closer look at things. All right, Jeff Brown says, good evening, Jess. Trish Wade, who's a regular, says, hello, everyone. Hello, Trish. Okay, the doctor has you squeeze her hands, you had injections to be able to use them, says you're fine. How after a few? Well, again, I think this comes down to what the consultative doctor is actually doing, and you should write down everything that happened. And when you get ready for a hearing, you or even before then, talk to your lawyer and see if there's an argument that can be made that this examination was not substantial enough to be able to lead to the conclusions that are in the report. Although I would tell you, look at the report. I mean, every once in a while you get surprised and the report comes back and is very helpful. You're not going to want to make a big deal about it. But if it comes back against you and the doctor talks about how much you can walk and stand, but he didn't or she didn't watch you walk and stand, then that you can argue that. And by the way, the other thing that you'll see in these reports many times is the doctor will say, I observed the patient or the claimant in the waiting room, or I observed the person walking in from the parking lot, and they were walking without a limp or without any assistive device. Yet when they came in my office, they were limping and they had a cane, all that stuff. So be aware that you're going to be watched from the time you pull into the parking lot and you go to the office. And again, I think people say, well, you're telling people to I'm not telling anybody to mislead him. Do the truth, but don't pretend to be something you're not, because that will be reflected in that consultative report. Okay. Okay. So Jonathan L., this is an interesting question. Had my hearing on the 28th, got an unfavorable decision, yet the vocational expert said no jobs. My judge sucked. 39% approval. All right. 39% is not good. Obviously not the worst, but not good. All right. This is something you said. The vocational witness said no jobs. Realize that the judge is almost certainly asked more than one question. And inevitably, the last question the judge asked would be, if a person was going to be off task 15% of the day because of, whatever medical condition, medication side effects, or this person's likely to miss 2 or more days of work a month, are there any jobs? VE will say no jobs. But you got to listen to the rest of the hearing and the other questions. There probably were 3 or 4 questions, and one of those reflects what the judge was thinking. I have a case, in fact, we just got it remanded back for another hearing, where my client told me that, the vocational witness said no jobs. I listened to the hearing, and there were 4 questions being asked, one of which was, of course, that, gimme question. But, so respectfully, Jonathan, I would tell you there were probably more than one question. And
Yeah.
that because there was one question that said no jobs, the judge chose not to use that as the basis for his RFC conclusion.
I mean, you can still use that statement of the
Yeah.
VE found no jobs based on this question.
Mhm.
And we use that a lot in federal court. Why? That's our theory, right? It's because there is something here. The
Yeah.
ALJ just didn't agree with it. But was that the right choice? Was that
Yeah.
right for the ALJ to not agree with it? So,
Yeah. Now, Jonathan says he asked one hypothetical. Again, I'm not, I mean, I wasn't there. That seems unlikely, but the next one he said off test 20% absent 3, you're going to say no jobs, correct. And then he dismissed him. So, oh, I see. He asked one hypothetical and there were 3 jobs. The second hypothetical was off task 20%. So obviously
yeah.
what the judge did was he took that first hypothetical. That was the basis of his decision. And what he said after the vocational witness, yeah, he knew that, look, judges know what the vocational witnesses are going to say. They've
Yeah.
been through these hearings. No surprise to them. So yeah, he knew the vocational witness was going to say no jobs. But he obviously made the decision that the first hypothetical was what he felt your condition was. Now, if you look, on appeal, the question is, was that hypothetical, did it reflect all of the limitations that you've got? That's what you would have an appellate lawyer, somebody like Adriana, look at to see if there is, a grounds for for an appeal. Now, do you do appeals counsel work or just district court work? Does your firm
We
do
just
appeal?
do the district court work.
Okay.
We find that oftentimes Social Security doesn't know what to do with 2 attorneys, and since we're not gonna do it on remand, right?
Okay.
Our job is just to do the district court case.
Okay. So
Um,
do
yeah.
you not do? I mean, you do hearing work or no hearing work? You're just doing
No,
appeal.
well, we're always happy to, consult with
Right.
other attorneys and say, "Okay, well, we got the remand. Here's what we would focus on
Okay.
if we were doing this hearing, if we were doing this." Or even at the appeals council level, we'll talk about what are probably the strongest arguments to raise to the
Okay.
appeals council level. But we're not doing appeals
Okay.
council
Now you're in
level
practice
work.
with your sister, I believe. Is that right?
Yes, my sister and I, we've been in practice since 2011.
Okay. Well, I'm an only child, so I have no siblings. But I would. That's. I'm in practice with my wife, which is, that brings its own challenges. But not having siblings, so I don't know. I assume you guys get along, so that's a good thing.
Yeah, yes, we've been doing this for all our lives,
Yeah.
actually.
Okay. All right. So I think this goes back to Cynthia's prior question. Their website, I'm not sure whose website you're talking about, Pricey Joy. Adriana's or mine, but maybe it's yours. I don't know. Hopefully it is. That's a good thing.
Could be both.
But actually, it's interesting you mentioned websites. I mean, I did years ago. I was like one of the first lawyers really in Georgia to have a real website, and it was great. I mean, I had really several years where business was booming quite a bit because nobody else had a website. Then of course everybody caught up, and then that's started getting into videos because that's a little more difficult to do. But websites now, I'm not sure who even reads them so much anymore.
Yeah.
But there are, there's some interesting. There's a couple of I forget what it's called. I can't draw a blank on the name, but like the best of every year. It's really interesting to see, what people vote to be the best legal websites and what they look like. And so it's very
Yeah.
inspiring sometimes to see because a good web designer with all the especially with some of the technology that can be done can really make it look really pretty neat, very interactive and so forth. Okay. What to expect in medical reevaluation of someone approved 4 years ago for MS? Oh, okay. This is one of my clients, how and when, or SSI. Again, I think that a reevaluation is going to be part of the CDR. I think they're going to. I think we talked about this a little bit earlier, but I think they're going to look to see, are you going to the doctor? They're going to ask to know, has anything changed in your condition? If it's MS, generally speaking, it's probably not going to be a dramatic improvement. I mean, you normally get a spontaneous, improvement on that. So, it's not likely they're going to move to terminate you. I think it's possible, but you have a chronic condition that is going to probably get worse over time. Unfortunately, obviously, you want to keep it as stable as possible, but I don't think that would be something other than they're going to want to see if you're going to the doctor and are you compliant with medications. George is one of my clients. Moved to step 4 in the final review. I think step 4, I was reading, somebody had written about this. Maybe Chad was talking about this. Step 4 is basically, they've made a decision, they haven't released it. But there's no time frame associated with it. It could be, it could be 6 days or it could be 6 weeks. It just means that it's moving through the system. And I think some of that step 3, step 4 stuff is just to make people feel better. I don't know if that means a whole heck of a lot. Yeah, that's my take. I get cynical sometimes about this, but you can't. But sometimes you can't help it. Okay, a foul says it can take up to 4 years. Yeah, it's exhausting. It surely can be. Surely can be. Okay, let's see where you're at. We got about maybe 5-6 minutes left, so I'm gonna try to zoom through a couple of these. What happens if you make a decision you're out of the country? No, as long as, again, you got to look at the decision. If you're going to appeal it, if it's unfavorable, you have 60 days to appeal. So I would tell you, if you're out of the country, have somebody check your mail and let you know if you got a decision, right? And of course, your lawyer will know. When I look at, I use, again, a couple of utilities, Chronicle, or you can actually log into the ERE system. I'll see it before my clients. So I check literally every day. And so if I see a decision, I'll then notify my client by email, this is what happened. I got one today, and so I emailed my client, said, here it is. All right. We just answered that. Judge had a 50%, 50% didn't look them up, didn't need more worry. Yeah, that's an interesting point. Some people don't want to know what the judge is like. 47%, she said, as opposed to, which again is kind of in the middle there. I personally like to know, because if I have a really low approval judge, I'm going to set my hearing up to maybe be more likely to get an appeal. Just the questions I may ask or what I may put in my brief. I just like to know. If I got a really high approval judge, I like to know that. I'm not going to say that's going to mean I'm going to get an approval, but it's just, I think it's useful to know the other way around as well.
But remember that even if they say one thing, you can show up and they changed it based on some
that's
sort
a
of
very
schedule.
good point. That has happened to me a couple of times, where actually happened to me on one of the cases I was talking about earlier, where we had judge 17%, and then my client went to the hearing, and the judge, because I think he realized that she was going to be a closed period, he's like, you need to get a lawyer. Because it was going to be kind of, needed to be explained. So she hires me. By the time the hearing came around, this judge had retired, and they got another judge who was a much higher approval rate, much easier to work with. So happened positive. On the other hand, I've been, had cases where they had a judge assigned to the case. I'm thinking, oh, this is great. I know this judge is really nice. I get there and you get a judge 30%. So it can happen. That's never a good sign. You can't really say to the judge, excuse me, you're not supposed to be here.
I was told I was supposed to get somebody else. That doesn't work.
I always prepare as if that's going to happen. It doesn't happen too much anymore, but I always like to pretend it could. I remember a few years ago, there was a time where they were not telling us who the judges were, and that was really unpopular. And so about 6 months after that, they kind of backed down on that.
Well, it was nonsense. It was complete nonsense.
It's just, okay. All right, we got time for a couple more here. RD is 56 with chronic bladder pain and frequent urgency, tailbone pain, pelvic pain. Do I have a good chance of getting approved? I think, anytime you have bathroom issues, in my experience, that is a good sign. I think judges realize that if you've got to take unscheduled breaks to go to the bathroom, once or twice an hour, that's going to be excessive, vocational witnesses will say. But again, is it because of what's the underlying diagnosis?
But make sure. Oh, sorry.
I'm coughing.
I would make sure that it's based off of medical records. See if your doctor is saying that. If you're saying just on your own, well, I have to go to the bathroom X number of times, during the day. Social Security is not just going to take your word for it. they're going to need something more, especially on something where, it could be as important as how many times you go to the bathroom.
Yeah. Keep a log.
Yeah.
Yeah. And tell your doctor too. I mean, tell your doctor if you're having to urinate, every 45 minutes, make sure that's in the medical record. Because again, and my take on it is what you say doesn't really mean a whole lot. I mean, it's got to be in the medical record. I think that, in my opinion, whether you win or lose is about 80% medical records, maybe about 10%, 15% your testimony, and maybe 5% your lawyer's brilliance. I think it's mostly what's in the medical record, I mean, because
Yeah.
that's what they're going to go by. And,
And
your
your
testimony,
testimony has
yeah,
to line up to the medical
right.
records.
Got to be
That's
consistent.
it. Like,
Correctly.
yeah.
Correct. Okay. Let's see here. Okay. I'm going to just make this, we'll make this one and win a couple more here, but okay. You've got a doctor you filed a complaint against, social worker, whatever. The doctor is saying things in the record. Again, that's a tough situation because judges aren't going to really be that receptive to that. I think that, you want to document it. I'd get another doctor. I mean, I know
Yeah.
sometimes that's really hard to do with insurance, but, I don't find that goes very far. My experience has been that just doesn't go very far. Judges are just not, they know people are upset when doctors don't support them. And to sort of say bias or I filed a complaint, I don't know that it goes very far. That's been my, okay, let's go. Let's get one more here. Okay. Mikey Allen, I'm 58, had 2 plantar fasciitis surgeries on both feet, can't stand all day at work, can't hardly get in my car. Do you think it's SSDI? Well, standing on your feet all day, that's not the issue. I mean, realize at 58, you could possibly win under the light grid rule, 202.06, if you could say, even if you could do light work, which is standing 6 hours, that you would be disabled, assuming no transferable skills. But not being able to stand all day is not the standard. You got to be more specific than that, and you need to have statements from your doctors that, talk about how long you really can stand. And I think that's going to make the big difference. And again, transferability of skills would be an issue. I would still tell you, and as I would tell anybody, if you can work, you should try to work. Is there another job you could do where you don't have to stand as much? You're going to be happier working. You're going to make more money. You're going to have a sure thing. You filed for disability, even though on its face it looks like a fairly decent case, it's going to be possibly 2 years where you're going to have no money coming in. So, those are the things you really want to consider. Okay, let's see. I think that, okay, I'll make this the last one. I'm going to let Adriana address it. Denise Manson, I've had 3 cervical surgeries. My hearing date's in July. Any other forms you recommend to my doctor letter and support in addition to office notes? What is your take on functional capacity forms narrative reports? How valuable are they?
I think it depends on what they're covering, right?
Mhm.
If you get a narrative that just says the claimant is disabled, my patient is disabled, that's as good as nothing, right? Like
Yep.
that's not going to move the needle. What
Right.
you need is something, and I think that's when you need to talk to your doctor and say, this is all the stuff that I have trouble with, right? And understand what is it, like you said before, what do I need to prove, right? Do I need to prove that I can't do any job out there? Or do
Mhm.
I need to prove that I can't do just light work, right? I can't stand for too long. Or maybe it's that you can't lift 10 pounds because of your cervical surgeries.
Mhm.
That's where you need to get into the details on what you can and cannot do on a regular and continuing basis.
Yep.
That
Yep.
is the trick, right? You may be able to lift the 20 pounds or the 10 pounds once or twice a day, but you can't do that regularly, day in and day out.
Yep.
So it's important that any kind of report from your doctor not only gives you the details about what is going on, but why you have that problem, right? Is it because of the numbness, the surgeries, the residual pain? Is it because of tingling? Like, what is it in particular that makes that statement from the doctor supported? And that's where I think you have a very
Yeah.
strong chance.
And look, I think that in many ways, what you want your doctor to do is to translate. I always would tell this to my clients, translate the medical issues into very specific work limitations,
Yep.
because, you don't want a diagnosis. It's really more about, getting those functional issues identified. So anyway, all right. Last question let me ask you, and again, I'm going to ask you to gaze into your crystal ball. Going down the road, what right? Mirror, mirror, no. What do you see? I mean, what trends are you seeing in terms of, is this going to take, are cases going to take longer to work through the system? Is it something that people should be discouraged? They're going to be fewer approvals. Do you have any sense of any of that?
I think that the cases are going to take longer. I
Yep.
think that that is just going to be moving forward, what's going to happen between changes within personnel, offices itself. I think within the states, we are talking about DDS, right? The
Mhm.
local agencies. I think that's going to be a trend that we're going to continue to kind of see.
Yep.
As for the approval rates, I feel like those have stayed relatively consistent over
Mhm.
many, many years. That it's not been, okay, at the ALJ level, nationwide, they only approve 20%. That's never really been the case. It's always
Mhm.
hovered around that 50. Some years it's 48%, some years it's 51%,
Yep.
but it's never this wide disparity. So I don't see that that's going to change all that much. Um, I do think that reconsideration, that's the next goal, is to kind of get rid of that step, right? Because if you look at the statistics, it doesn't really do much. The cases still have to get to the ALJ. You're just asking the state agency to do again what they already
Already
just did
did.
and didn't work.
Right.
So there has been a push, and there was a push to get rid of reconsideration. They took 10 states and got rid of reconsideration for a while.
Yep.
And what they've realized was, well, the whole rest of the country has reconsideration, so we're already built for it, might as well
Yep.
just put it back.
Right. Right.
Doesn't mean it's the right step, right? So, there's some of that hopefully will bring about some of the change, but I think what matters to people is you're still going to be able to file. It's still going to be there. You're still going to have to prove your case, get your medical records, and you should be okay.
Yeah. Although I do think that AI will become a part of this, whether that's going to be
Yeah,
next year or 5 years from now. I think there will be AI models in place that will be used to make decisions. And again, we're already seeing an effort to catch those really strong cases early. And I think we're going to see more of that. So the ones that are denied, they'll go through the process. But I think that, and we don't see a lot of, look at the hearing level, I don't see a lot of listing level cases anyway. I think most of
right.
those get caught early. But I think that's the thing. But I would agree it's going to take longer. So obviously, if you're thinking about applying and you haven't done so, no reason to wait. You don't need to be. That's one thing people always say to me, I have to be out of work for a year. No, you have to have a
Yeah.
condition that's likely to keep you out of work. So you could be out of work for one day and apply. So I would say do it sooner rather than later, if you're going to do it. But think about it before you apply. Really think about, are you prepared to sit at home looking at the four walls for the next 2 years, 2+ years, hoping that you'll get a good judge and hoping that Social Security is going to do the right thing.
I
And I
think the
think that's,
trick with the AI, I will say, is how much are they going to tell us,
yeah,
right?
yeah,
Because how are they going to tell us how they're training the,
yeah,
the bot? Are they going to tell us what information they're putting in, who's accessing that information? Where there's going to be a lot of information that I'm going to want to know
yep.
about how they're using AI. I'm not entirely sure I'm going to get it, but I would
I
love
don't
to
think
know.
they're going to want to tell you. That's true. That's true. All right. Before we go, tell people, and I realize that you're doing, federal court work, and obviously it's somewhat specialized. But if somebody has gone to a hearing, been denied, they denied at the appeals council, and they're looking for a federal court lawyer to review the case, and realize that Adriana does not take every case that comes through. You can't. because not all of them are worthy of that. But if somebody wanted to reach out to you, now you got on the screen, your Tower Law Group at www Tower Law Group. The phone number, that's the best way to reach out to you.
You can send us a call. You can give us a call. You can also send us an email. Our email
Okay.
is disability@towerlawgroup.com.
Okay.
So you can send us the information with your contact information. We'll reach out, make sure that we can get everything that we need to review the case to see if we can help. As I said, the district court it remands a lot because Social
Yep.
Security makes a lot of mistakes. So, if there is a way that we can help, we'll always be
Yep.
wanting to do that.
And by the way, anybody who wants to, if you're on LinkedIn, I would say follow Adriana, because there's some really, it's really interesting so much you share about some of these cases. You'll kind of look at an interesting case and kind of break it down, which is really very interesting for somebody like me, because again, I'm not in federal court, and it really helps me understand kind of what's going on. You kind of pick up on trends, and like I said, these things can be useful at hearings. So if you are inclined, and again, it can get a little technical at times, but if you're inclined to kind of ramp up your knowledge about this, then I would say you're a great person to follow on LinkedIn. So
Thank you so much. Yeah, you
there you go.
can send me a connection on LinkedIn. It's Adriana Della Torre, and I think I will come up. There's not that many of us out there.
No, I was going to say probably I know it's funny with Ginsberg. Obviously there was Ruth Bader Ginsburg, who I'm not related to. Obviously it was her husband's name, but there's not very many of us. But there are several Ginsburgs who are lawyers. In fact, there was a Jonathan Ginsberg who was an immigration lawyer, fairly well thought of, and I used to get these, emails asking me to speak at an immigration conference. I'm like, why would somebody want me to speak at an immigration conference? And I realized finally, I found out that it was another Jonathan Ginsberg. So, it's it's in when you have a little bit of a different name, it's not that hard to find you. So that's good. So, well, again, I
It's not hard to
appreciate.
find me.
I appreciate very much your coming on, and we'll hopefully do it again. It was a lot of fun and great getting your perspective on things, and we will talk again very soon. So
Yes, thanks so
thanks
much.
so much, and everybody, and have a great weekend and a great week, and we'll see you all next week.
Thanks.
All right.